Hello everyone, this is Aparna Bhat. Welcome to Unacademy Judiciary YouTube channel. Today I am going to discuss a very important topic in Code of Civil Procedure, that is costs. What is a cost? Because while giving a judgment, while delivering a judgment, while pronouncing a judgment, the court will consider some of the other factors apart from the merits of the case. There are merits, there are certain situations where the court will either decree or the court will either dismiss the suit. This is all we know. But there are also other aspects where the court will award interest, the court will award costs. So there is a general saying that cost follows the event. So it means whoever is the successful party, he can get a particular cost of his proceedings from the party who is unsuccessful. So that's the meaning where we can understand the cost follows the event. And even sometimes we see in the judgment that parties to bear their own costs. So it means that no party should give the cost to another party, but they should bear their own costs. So this is something where costs are calculated. There is a particular method. Different states, different high courts, they have their own civil rules of practice where they have stated how to calculate the particular cost, how do we calculate. Regarding all these things we see. This is for sure that some costs are considered, but in Code of Civil Procedure we are having certain guidelines. So those sections, as we can see in the slide, that is section 35, section 35A, section 35B, and also some of the provisions in order, that is the first schedule where you can see order 20A relates to costs. So different types of cost can be imposed, different types of variety of costs are there. So the general provisions relating to costs are so and so. We can see from section 35 onwards, section 35A, section 35B, so all these sections are there. So I want to also mention about another fact that there is a judgment. While delivering the judgment, the court will award costs. Suppose during the proceeding, during the trial, if any party is causing delay, the court may immediately impose cost on the other party. The court need not wait till the disposal of the suit. Suppose I am a party, I am a witness, I am supposed to produce the evidence, that is I have to bring the witnesses. So I am causing too much of delay for examination of the witnesses. Then the court may order that, or my witness is present, the other party is delaying for cross examination, he is not conducting cross examination properly, he is taking day after day, day after day. Then what happens? Even in such cases, the court may award costs. So this is for causing unusual delay, simply causing delay. You can see that there are costs which can be imposed for one such thing, and not till the disposal of the suit. The court need not wait till the disposal of the suit, but in the course of the proceedings only, during the proceedings only, the court can award the cost. That is one thing. And in another case, if I have to give example, like simply a vexatious case is filed. In such cases, what will happen? The court, of course, for filing false suits, it will award costs. And in order 20A, we can see different petty costs for typing, for other charges, for different expenditures which has been incurred by the party. For such things, cost can be awarded. So cost is a very interesting subject if we understand them. So for every operative order, the operative portion in the order or the judgment, we can see reference to the cost. So different statements are there. Even in different judicial examinations, we can find questions regarding cost. So they may ask, what do you mean by cost follows the event? What do you mean? Cost, the party should bear their own costs. So such things, such sentences they will give, and they will ask, what do you mean by this? Who should pay the cost to whom? Okay. So this was a very introductory portion regarding cost. So if we have to see, as you all can see in the slide, there are different types of costs which can be imposed by the court. The first one is regarding general cost. Section 35 is regarding general cost, where after the trial, when the suit is been disposed, either when the court is giving judgment, at that time generally costs will be awarded, and that to the general rule is whoever is a successful party, he is entitled to the cost. The unsuccessful party should pay the cost to the successful party. Then comes the miscellaneous cost, which is under order 20A. Then we have compensatory cost. This is in the nature of a compensation. Why? Because the other party has filed a false and vexatious case against me, or vexatious defense. I have filed a proper suit, but the other party is filing vexatious false defense. For that, as a way of a compensation, I will be getting the compensation as a way of in the nature of a cost, that is provided under section 35A. And the last one is section 35B, where I just recently mentioned about how costs are for causing delay. If you cause a delay, how costs are awarded, that is being passed. Okay, these are these are the four category of cost which we can understand while delivering. Maybe not only in the course of judgment, even the fourth one, the cost for causing delay, can be awarded at any stage of the suit. Okay? Yes, this is the one thing. So let us understand what is a general cost, because see, the object of general cost, section 35 deals with the general cost. The object of awarding cost to a litigant is to secure to him the expenses incurred by him in the litigation. I am a litigant, I have filed a case, I have incurred certain expenses, maybe legal fees, for postal charges, for summons, for photostat copies, for the pages. So different expenses, for the court fee, I have incurred certain expenses. So it neither enables the successful party to make any profit out of it, nor punishes the opposite party. The sole object of awarding cost is nothing but reimbursement. Whatever cost I have incurred in carrying out, in contesting the suit or in filing the suit, that much cost is being tried by the law to get reimbursed to me through the channel of the opposite party. It means the unsuccessful party will be paying me the cost if I am successful. This is what the general cost mean. So if I am successful, it does not mean that I can make profit out of that. The court will never award such costs. It may award cost as a way of compensation when there is a false case, vexatious case. But the intention of awarding general cost is neither to make any profits for the successful party, or neither to punish the opposite party. Okay? So this is what the general cost, the object is, and there is a statement which says that the cost shall follow the event. Cost shall follow the event. So the general rule relating to the cost is that cost should follow the event. Means whatever the event happens, according to that, cost will be borne by that person. If it means successful party will be getting the cost and the losing party should pay the other side. The losing party will be paying the cost to the other side. This is regarding the general cost. Then we come across miscellaneous cost. This is found under first schedule in order 20A. Order 20 is with reference to the judgment. Order 20A is for the miscellaneous cost. What does this say? What does this order 20A say? So order 20A makes specific provision with regard to the power of the court to award costs. So even order 20A is for awarding the cost, but what kind of cost? See, it shows certain expenses. It lists out certain expenses regarding giving notices. While giving notices, for typing charges, for inspection of the records, for obtaining copies, and for producing witnesses. So with reference to all these, certain charges are paid by the party. So that cost can be recovered. That is provided under the first schedule, that is order 20A, under the head of miscellaneous costs. So, we have covered section 35 and order 20A. Section 35 was with respect to the general cost and order 20A was with respect to the miscellaneous cost. Then comes compensatory cost, which is for section 35A. See here, what is the object of section 35A? It says that it provides for costs which are compensatory in nature. Here the purpose is to compensate the successful party, because the purpose of general cost is not that. This is added by way of amendment. Earlier section 35A was not there, 35B was not there, but later it was added by way of an amendment. And when that is the case, what is the purpose of awarding compensatory costs? Compensatory costs are awarded for providing compensation. So, this section is an exception to the general rule. That is why we say, see, general rule says costs are only an indemnity and never more than indemnity. So, what do we mean by indemnity? Indemnity means making good the loss. If any loss has occurred to someone, that loss is reimbursed, that loss is covered by paying that much amount. General rule says that costs are only for doing indemnity, for making good the loss, for only for the purpose of indemnity, and nothing more than that, nothing for profit, nothing for punishing. This is the general rule. But 35A is an exception to the general rule. It says that it is for compensation only. So, this section is intended to deal with those cases in which section 35 does not afford sufficient compensation in the opinion of the court. Court can award compensation under section 35, but even when that cost is not sufficient, court can also award compensatory cost under section 35A. So, under this provision, if the court is satisfied that, so there should be some conditions for awarding this cost. So, what is that cost? If the court is satisfied that the litigation was inspired by vexatious motive and was altogether groundless, so such claim is completely groundless. It's not having any base. If any suit has been filed and simply to trouble the other side, if I am filing a case because I have a grudge against Mr. B, I want to remove my hatred towards him. So, what will I do? I will simply file a case. So, that is a kind of filing a false or vexatious case. When the court comes to know about this, how does it come to know? By the merits of the case. When there is no base on this, when the case is groundless, what will the court do? The court will naturally dismiss the case, but it will provide compensatory cost to the defendant, or this is awarding compensatory cost for the defendant. Or if I have filed a case, my case is very genuine case, but defendant sets up a completely false or vexatious claim, false or vexatious defense. In such a case, what will happen? Again, upon the merits, the suit may get decreed, but the court may award compensatory cost in favor of me, that is the plaintiff, against the defendant. It may ask the defendant to pay compensatory costs in addition to the general cost, which is naturally awarded in all kind of suits. Okay? That is one thing regarding section 35A. So, this section applies only to suits and not to appeals or to revisions. So, because this is at a very basic level, the initial level, where claim is there, where a false claim is there, or where a false defense is there, where vexatious claim is there, or where there is a vexatious defense. Okay. This is regarding the third category. So, we have completed general cost under section 35, we have completed compensatory cost under section 35A, we have completed miscellaneous cost under order 20A. Then is the last one. Okay, before that, under section 35A, there are certain conditions which it has to fulfill. Okay, the following conditions must exist before this section can be applied. The claim or defense must be false or vexatious. Only then, if it is a genuine case, both the parties are contesting according to their actual status and case, then compensatory cost cannot be awarded. but only when these conditions exist, that is when there is a claim or defense which is false or vexatious, or when the objections must have been taken by the other party that the claim or defense was false or vexatious to the knowledge of the party raising it, and such claim must have been disallowed or withdrawn or abandoned in whole or in part. So, the court must have taken some action. It should have either disallowed, or the parties might have withdrawn that, or the parties might have abandoned the whole claim or abandoned the part claim, withdraw the whole suit or withdraw the part claim. So, it could be any possibilities, okay, but the ultimate outcome of this suit is some false or vexatious claim has been filed, or some false or vexatious defense has been filed, due to which the other party, the genuine party, is getting the compensation in the nature of a cost under section 35A. Okay? Yes. So, this is conditions which have to be fulfilled in order to award compensatory cost, but there is a limit. There is a monetary limit which has been imposed to award compensatory cost. You cannot award 1 lakh, you cannot award 50,000. So, the maximum amount which can be awarded under section 35A is rupees 3,000. So, the maximum amount. So, remember this monetary limit. Most probable question for the multiple choice question, where they ask what is the maximum amount of limit which can be awarded under section 35A, and the options would be rupees 3,000, 3,500, rupees 5,000, like that the options will go on. So, what does it say? The maximum amount that can be awarded by the court is rupees 3,000, but a person against whom an order has been passed is not exempt from any criminal liability. See, there is a civil liability and there is a criminal liability. Just because the person who files a wrong case, false case, he can also be subjected to criminal proceedings. So, that is a separate thing. By just, if any court awards him compensatory cost, that does not mean that he cannot be subjected to prosecution in criminal proceedings. He can be subjected to criminal proceedings also. There is a criminal liability for him. Okay? So, but whatever some suit may be filed for damages for compensation for false or vexatious case. We can file a suit for claiming damages for filing false case. In that amount can be adjusted, that amount can be taken into account. It means earlier, let me give an example. I had filed a genuine case, the other person I had filed a false case where it got dismissed. I was awarded compensatory cost of rupees 3,000. Okay? The other party later he will file a suit against me for damages for filing false case. So, there he is asking for rupees 50,000. The court will award 50,000, but previously I had also paid 3,000. So, that amount will be taken into consideration, 50,000 minus 3,000. So, totally I am supposed to pay rupees 47,000, and also I am having criminal liabilities there because I have that is a malicious prosecution which I have done. So, criminal liability is also there upon me. So, just by the order of compensatory cost, that does not mean that the person is absolved from criminal liability, he is absolved from other civil liabilities. It does not mean, it still continues. So, this is regarding section 35A compensatory cost. Then the last one, the last portion, very important portion, is section 35B. This is regarding cost for causing delay. This is especially, as we can see, this is added by way of amendment in 1976 itself. So, the purpose of adding this section is to put a full stop on delaying tactics. If I am causing delay, if I am a party, purposely I am taking adjournments upon adjournments, I am taking dates, different dates for the different maybe for evidence, maybe for filing some application or filing objections, then if I am causing delay, delay is being caused to the proceeding because of me, because of my fault, then I will be awarded the cost at that stage only. It is not at the end of the suit, but at that stage only I will be awarded the cost. So, it is inserted to put a check upon the delaying tactics of litigant parties. It empowers the court to impose compensatory costs on parties who are responsible for causing delay at any stage of the litigation. Such costs would be irrespective of the ultimate outcome of the litigation. Okay? So, whatever, maybe I may win later, my suit may be decreed, but initially I have caused delay, I will be awarded the cost at that stage only. So, it does not depend upon who is successful party, who is unsuccessful party. It just depends upon, it's a kind of control for delaying tactics by the litigating parties. The payment of cost has been a condition precedent for the further prosecution of the suit if the party concerned is a plaintiff and the defense if is a defendant. Okay, so I had taken that example. So, I am causing a delay for filing objection. So, the court, I took 3 days, but still I am not filing an objection for a particular application filed by the plaintiff. Then what will happen? The court will award cost on me. I should pay 500 rupees or 1000 rupees, and if I have to, if my objection has to be accepted, only upon the payment the court will allow that stage, because it was me who has caused the delay. So, for any stage, not only for filing objection, but for any prosecution or for any defense, only after the payment of the cost which has been imposed under section 35B, the court will allow the next stage, be it plaintiff or be it defendant. The outcome could be anything. Okay. This is regarding the cost for causing delay under section 35B. Yes. So, this was all about our costs. So, generally if we have to see the overview, we have 4 type of costs under section 35, a general cost, miscellaneous cost under order 20A, then section 35A which speaks regarding compensatory cost for false and vexatious claims for defenses, and section 35B for which is for cost for causing delay. Okay. I hope whatever I taught in this period, I am able to convey the meaning of the costs and other related concepts. Okay. So, this is all about cost, and when it comes to the recent updates of Unacademy, you all may be knowing Unacademy platform. We have judiciary category where we are conducting different classes for different states, different batches are there. So, in order to obtain the subscription, in order to join the batch, different batches, you have to obtain the subscription which is plus and iconic subscription. But on all subscription amount, it could be plus subscription, it could be iconic subscription, or it could be Unacademy light subscription. There is an offer which is going on, that is flat 20% off on judiciary subscriptions. So, the offer is valid from February 16 to 21. Okay. So, this is a very good offer, because see, whoever is preparing for judiciary 2023 for this year, it is better for all of you to take 6 months subscription. So, the total amount would be for 36,736 rupees. And if you are preparing for 2024, then it would be apt for you all to take 12 months subscription, and this is valid for 12 months, and the offer price would be 50,511. So, actually the price is more, but during this offer period, if you apply the code, if you apply this code Aparna law, then you are eligible to pay only this amount 36,376 or 50,511, and you can get the subscriptions. This is a very important update. The offer is valid from February 16th to February 21, and a very important announcement, because there is a free All India Judiciary Scholarship test which is going to be conducted on March 5th at 12 p.m. So, you are having the option to avail 100% scholarship amount. So what does this mean? By availing all these kind of scholarship, you are entitled to watch all classes, because all plus subscription or iconic subscription amount, that will be provided by way of scholarship. So you are having the chance, if you get a rank in this scholarship test, for this you can scan this code and you can enroll into that particular class for test. And coming to the different batches, we are launching different batches like Safalta 4.0 comprehensive batch. This is for the period of 12 months. Okay. Then you have linking batch for RJS and the Gujarat Judicial Service, Rajasthan and Gujarat. This is for a period of 6 months. And the start date is February 18th, whereas Safalta batch, it is going to start from February 16th. Then you have revision batch for Uttar Pradesh mains exams, that's for 3 months, which is going to start on February 23rd. For all kind of enrolling into the batches, you can use my code Aparna Law. Then you have Chhattisgarh Judiciary Prelims mock test series. See, different mock tests are required for all of you, because how much you prepare for mock tests, that's a very good option for excelling in your examination. How much you attempt, the success rate of your examination depends upon how much you attempt for your exam, how much you practice regarding previous year questions, how much you practice about mock tests. Regarding all these things, the things count. So one such mock test series is regarding Chhattisgarh. Already we had Uttar Pradesh mock test series. Likewise, we have Chhattisgarh Judiciary Prelims mock test series as well. So this is available only for a price of 500 rupees. So you can avail this 500 rupees, and also offer price could be there by applying the particular code. You will be getting 5 mock tests, and this will be exactly replica of your Chhattisgarh judicial examinations. So you also will be getting detailed solutions, and also unlimited attempts will be there. So you can see the dates, different dates are there. This is the test schedule which you can see. Then you have main test series for Punjab Judiciary 2023, because after prelims, mains test exams are also important, even tests are important. Here you can see exactly in the pattern of, so you will be getting 3 mock tests for Punjab Judiciary, Punjab mains examinations, and even model answers also will be getting. Each mock test will be having civil law 1, civil law 2, criminal law, English and Punjabi. So the total amount would be for 4,999 rupees. So total amount, but you also get offer price by using my code Aparna Law, APARNA LAW. This is one mock test, and another mock test is there for Uttar Pradesh. Uttar Pradesh means test series for Uttar Pradesh Judiciary you are having. So here you have mock test for general knowledge, English, Hindi, law paper 1, law paper 2 and law paper 3. The test schedule is, see, you have over a span of time you are having the test schedule. The pricing is only for 2,999 rupees. So it's a very good offer, and this offer is valid only for first 100 subscribers. So this is also important. So you can avail this price at a very reasonable price. Those who are attempting for Uttar Pradesh Judiciary, you can use Aparna Law as the code and you can avail the discount. And most of you may be knowing that Unacademy Judiciary is having different YouTube channels. Unacademy Judiciary, we are conducting daily YouTube classes, and even in Let's Crack Judiciary YouTube channel, different classes are being conducted. Even on Unacademy platform, free live classes are being conducted, plus classes are there, different batches are there. So I am conducting classes with respect to Karnataka state in Kannada and English. In both of the languages, we are having a batch which is Karnataka batch. The duration was for 6 months. It has commenced on January 5th, but still those who are interested, even they can join, they can take 6 months subscription, and they can watch all the previous recorded lectures, and they can join the future upcoming live classes. Myself and Swati ma'am will be taking the class. And my other classes, we have rapid revision Uttarakhand batch, we have rapid revision West Bengal batch, where even I am taking different subjects like jurisprudence, company law, insurance. So they are about to begin, they are yet to begin. So these are all different class details. So every morning from 6 to 7:30 I will be having the class for in English, which would be in English, and in evening in Kannada I will be taking, presently I am taking Code of Civil Procedure, and at 7:15 I am taking Karnataka Rent Act, which is a local law for Karnataka batch. So for any details you can contact the number which is provided as 85858585 for more details. So this was all about the cost and the important updates regarding Unacademy batches and Unacademy mock test series. So this is what I wanted to say. I will be meeting you in my next session with a new topic. It could be either in English, and also sometimes I will be taking classes in Kannada as well. So thank you all of you for joining. Have a good night.